Hello, this is Matt on the Moon Lambo channel. The SEC has officially dumped their expert witnesses in the SEC v. Ripple case. In particular, you may recall one Dr. Albert Metz. Oh, this prized Jim, let me tell you what. He wrote a massive report, which is in the public domain. I've covered it on my channel before, and I can't remember how many pages, but I think it was somewhere in the neighborhood of 100, maybe in excess of 100 pages. Put together on the taxpayer's dime. Mind you, the SEC's paying these expert witnesses to prepare all this information and to testify. And if memory serves, the payment is something like $600 an hour, so it's not exactly cheap. Well, this guy put together this report, and part of what the report is trying to prove is that if not for Ripple, the price of XRP never would have gone above 2 cents. I kid you not. Which means that XRP would have been the only cryptocurrency in existence, if that were true, to not go on a parabolic bull run in 2017 and early 2018. It would have been the only one. And he thinks that makes sense. And if you've been participating in crypto for the last several years, my God, you already know that's a bunch of BS. So he's out. And then there was also Patrick Doody, who, don't blame me, I didn't name the guy, but Patrick Doody, he claimed to know why XRP holders were purchasing XRP. Now, as far as we know, he didn't actually speak to any XRP holders, but that's another expert witness. The SEC has dumped these fools. Wasn't going so well. So we're going to take a little trip down memory lane, and I'll end up sharing with you what Attorney John Deaton had to say. But, man, talk about fail town. SEC just, SEC lawyers. Do you even lawyer, bro? It doesn't look like it. But I want to clear at the outset, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now let's do a little table setting here, a fun little refresher, so you can see just how intensely the SEC was doing a couple things to make sure that their experts were able to contribute as much information as possible, while also attempting to shield that information from the public, because the public, obviously, meaning you and I and everybody listening here, everybody in the XRP community, we would tear it to shreds because we know it's a bunch of jibber jabber and hoo-ha, right? Bunch of malarkey. Well, they went to extreme lengths to do those things, only to ultimately not even, and paying them, only to not use them when it comes to the motion for summary judgment. They're just out. They decided that it wasn't going to help their case. Too hard to argue that. Isn't that hilarious? But so look at what they did, though. Here's an article from April 20th of this year from the Crypto Basic. This one's titled, SEC Slight Win as Court Denies Ripple's Move to Dismiss Dr. Albert Metz Supplemental Expert Report and Other Developments. And this one I don't even want to read, but I just wanted to refresh your memory. Dr. Albert Metz, one of the SEC's paid expert witnesses who wrote that roughly 100-page report saying a bunch of nonsense, he submitted that. I am pulling from memory here, but I think it was the later part of last year, might have been November. Well, Ripple's expert witnesses took a look at that, and they started critiquing it and stating that the methodology used was faulty. And if that's true, if that ends up being true, of course, then you can get the whole thing tossed out. And that's called a Daubert motion. You may have heard that, talked about in the XRP community. I've talked about it in my videos. So if there's that type of Daubert challenge, if the methodology is flawed, or if the person, you can prove that they're actually not an expert, then you can get all of that thrown out anyway. But anyway, so the methodology was challenged, and as a result of that challenge from Ripple's expert witnesses, the SEC expert witness Dr. Albert Metz filed a supplemental expert report. And I believe that was in the later part of February the following year, which means this year, 2022. And the problem is, in filing that report, it was outside of the rules and timeline for the court, so it should have just gotten denied. Now, Judge Neppert ended up approving it, and a lot of people, I think, reasonably critiqued that it's outside the rules, but she said, okay, we'll allow the report anyway. And it's like, okay, it is what it is. I remember reporting on that back in the day. But that's the SEC fighting to have as much information as possible from these fools that they ended up not even using in the damn case after paying them $600 an hour or whatever the hell the dollar figure was. And then there was this, May 22nd this year from AMB Crypto. SEC v. Ripple. Amici takes aim at reasonable XRP holders' assertion. The lawsuit between American regulators SEC and the San Francisco-based fintech firm Ripple continues to see new developments. Ergo, it is perhaps no surprise that holders of XRP have grown impatient given the dynamics and volatility of the cryptocurrency space. Bearing this in mind, John Deaton, counsel for Amici Curiae, has filed a letter asking U.S. District Judge Annalisa Torres to consider the views of XRP holders. The status, which is Latin for friend of the court, refers to someone who is not a party to a case, but who assists the court by offering information, expertise, or insight that has a bearing on the issues being discussed. John Deaton has filed a motion letter asking the judge to permit him to write a brief on behalf of 67,300 affected/hurt XRP holders. And I'll pause to note, that number is now, I believe, over 73,000 XRP holders he represents. Anyway, piece continues. This move comes on the heels of testimony from an expert SEC witness Patrick B. Doody, who gave a report on what information reasonable XRP holders relied on while buying the token. So, folks, looks like we're never going to see this report because the SEC dropped him, right? I mean, that would have been a while if we were ever going to see it potentially anyway. I don't know for sure if we would have, but now we're definitely not, right? It seems like a certainty. Now, popular attorney James Filan was one of the first to tweet about this development, claiming, quote, Amici request permission to file brief regarding SEC expert who claims to know motivation of XRP holders when purchasing XRP. Amici also seek access to experts' report and deposition testimony, end quote. Ergo, they use ergo in this article. Ergo. Amici John Deaton, representing 67,000 actual XRP holders, would provide the court with a meaningful perspective. It would ensure complete and plenary presentation of the said issue, helping the court reach a fair conclusion. Now, such assistance would prove to be beneficial during a briefing on dispositive motions. However, the court may exercise its discretion to request or deny further applications as appropriate. So whatever the case, optimism is high given the previous green light. Last October, the judge's order granted Amici Curiae status to 25 XRP holders. And here was a quote. And this is why it's as clear as day. This is the exact type of thing that Attorney Deaton should be able to write about. And the quote is, movements in their individual capacities shall be permitted to act as Amici Curiae in this action. As such, movements shall be allowed to assist the court by briefing legal issues relevant to the case as approved in advance by the court. End quote. Now check this out. This is where Attorney Hogan jumped in, and you can see the tweet on the screen right here that covered it in the article. He wrote, John Deaton is marching into court. The SEC wants an expert witness to give testimony about what XRP holders were thinking when they bought XRP. Deaton represents 67,000 actual XRP holders and wants to present what they were actually thinking. So, of course, the SEC opposes it. So think about that. The SEC fighting to have Attorney Deaton not be represented because it would be very harmful to whatever the hell Patrick Doody would end up reporting. Because Patrick Doody was pulling some duty out his rear side with all the nonsense that he would have ended up spouting. And fine, look, haven't seen the report, okay. What do you think, though? I think that's reasonable speculation. So look at how they shut it down. And then there was also this here. Ripple slams SEC bid to shield experts in high-profile crypto case. This is from Reuters. The U.S. Securities and Exchange Commission has made an unprecedented move to keep the names of its expert witnesses under wraps, Ripple Labs Inc. said in a filing in the agency's highly watched case over the cryptocurrency XRP. And by the way, this is from, where's the date on this? July 11th. I apologize. July 11th. The San Francisco-based company told U.S. District Judge Annalisa Torres on Sunday that the SEC had insisted Ripple's challenges to 3 SEC experts be filed under seal until the judge decides whether to shield the opinion of a 4th expert when the SEC has faced threats and harassment. So there you go. They were pushing to make sure these experts, their voices would be heard. They were also trying to squash Attorney John Deaton from participating in any sort of response having to do with Patrick Doody. And all these efforts in trying to seal in this, they wanted everything under seal ultimately. These are just a few of the headlines. All of that, and then they just completely dump their own paid expert witnesses because the arguments weren't good. I'm speculating, but the arguments weren't good. Like I don't even have to speculate actually when it comes to the Dr. Metz report. That's garbage. I covered that on my damn channel. Like that was a piece It's just like a flaming heap of a dumpster fire of a report. Like, it's complete trash, complete garbage. And so Attorney Deaton, just this morning, tweeted out the following on this topic. He said, "As I said earlier, the SEC chose to not rely on experts. They had expert one who was trying to say what XRP holders relied on when acquiring XRP. They gave up using that expert because we acted. That was the only Hail Mary it had at proving secondary market XRP is a security." So the SEC arguments continue to just unravel. They were never strong to begin with. But the more things progress, it's just that much more plain to see how this is all falling apart. And do you see how absurd this is? Like, I remember covering, all these videos covering all this stuff, dating back to, earlier this year, talking about Dr. Albert Metz and Patrick Doody, with a very unfortunate name, covering all the stuff that they were doing, all the hoops that they were jumping through. And they're not going to use any of that content for this case. Why do you think that is? Perfectly reasonable to make the argument that it's because it wouldn't be helpful. Well, that's very clear. Wouldn't be helpful to the case. The question is why? Well, in the case of Dr. Metz, that's very clear. I still think it's rather clear with Patrick Doody, slightly less clear, reasonably so, because we don't have the actual report. But come on, the idea that this guy was going to come out and say why all of us were purchasing XRP, and as far as we know, he didn't even speak to any XRP holders, and then you have thousands and thousands of XRP holders who told John Deaton and were willing to have this shared in court why they actually purchased XRP. That's damning. So they ended up dropping all of this. Pretty amazing stuff, is it not? That's why I'm like, SEC asshats, do you even lawyer, brah? It doesn't look like a lawyer, brah. I'm just saying. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.